All right, let's dive into a really fascinating legal story from India. It's all about what happens when a marriage is, for all intents and purposes, over, except on paper. This is a story of old rules clashing with new realities and a decades-long struggle to answer one pretty simple question. When is a marriage truly finished? Let's get into it.
This quote from the incredible Justice Christian Iyer, wow, it just gets right to the heart of it, doesn't it? He's basically asking, what is the point of forcing two people to hold on to something that's only causing pain? I mean, if a marriage has become nothing more than an empty shell, a relationship of all thorn and no rose, shouldn't the law give people a way out? This was the human problem the legal system was facing.
And that's the core of it right there, the empty shell marriage. You know, it's a union that exists legally on a piece of paper, but in reality, it's completely broken down. The love, the respect, living together, it's all gone. And for a long, long time, traditional divorce laws had no real answer for this because they were built on a totally different idea. And that idea was fault. To get a divorce, you had to stand up in court and prove that your partner did something wrong, something specific like adultery or cruelty. But what if nobody was really at fault? What if two people just grew apart and the marriage died a natural death? Well, under the old system, they were legally trapped, sometimes for life.
So the Indian parliament saw this happening. They saw people being forced to stay in these miserable, broken unions, and they decided, okay, we've got to do something about this. So back in 1964, they came up with a modern solution, a new rule designed to reflect how relationships actually work in the real world.
And this solution was Section 13(1)(a) of the Hindu Marriage Act. Now, this was a huge deal because it wasn't about pointing fingers anymore. The whole point was to give people a legal exit when it was crystal clear that the marriage had irretrievably broken down. The focus was on the reality of the situation, not on who was to blame.
So how do you prove the marriage has broken down? Well, they made it super simple. The law set out two clear conditions. First, if a court had already granted a legal separation and the couple hadn't gotten back together for a year or more, or second, if a court had ordered one person to return to the marriage, what's called restitution of conjugal rights, and they still hadn't reconciled after a year. That one-year waiting period, that was the proof that this marriage was beyond saving.
But here's the really revolutionary part, the absolute kicker. The right to file for divorce under this new rule was given to either person. It didn't matter who was the guilty party or the innocent one in the first place. Parliament's thinking was obvious. If the marriage is this broken, what good does it do to force it to continue? But this progressive idea, well, it was about to cause a massive legal headache.
And this is where our story takes a wild turn, because this brand new forward-thinking law ran smack into a much older, pre-existing rule that was still on the books. And this created a direct contradiction, a paradox that would completely baffle the courts for years.
Okay, so look at this. On one hand, you've got the new rule, Section 13(1)(a), saying either party can get a divorce after a year of separation. But on the other hand, you've got this old rule, Section 23(1)(a), that says a court can't grant a divorce if the person asking for it is taking advantage of their own wrong. You see the problem, right? It's a complete clash.
This led to the million-dollar legal question, what happens if the spouse who files for divorce is the exact same one who refused to obey the court order to get back together? Are they taking advantage of their own wrong? Is just refusing to reconcile a wrong that stops them from getting a divorce? Which law is supposed to win this fight? And this contradiction, as you can imagine, sparked a massive legal tug-of-war that played out in courtrooms all over India. For years, judges really struggled to figure this out, leading to all kinds of conflicting decisions and just a ton of confusion. At first, the courts were pretty old school about it. Most high courts leaned really hard on that old own wrong rule. They basically said, look, if you're the one who disobeyed the court's order to get back together, you can't then turn around and use your own disobedience as the reason to get a divorce. And that interpretation, well, it pretty much canceled out the entire point of the new law.
Let me give you a classic example, a case called Chaman Lal versus Mahinder Devi. So here's what happened. The wife got a court order telling her husband he had to come live with her again. He just refused. Then, after the one-year waiting period was up, he's the one who files for divorce. And his reason? The fact that they hadn't gotten back together. He was literally using his own non-compliance as the basis for his case. So what did the court do? Its answer was a big, emphatic no.
The court flat out denied his request, saying that giving him a divorce would mean letting him take advantage of his own wrong. This just goes to show how that old fault-based thinking was still very much alive and kicking, and it was getting in the way of this new idea of marriage breakdown. But, of course, the story doesn't end there. As time went on, the Supreme Court of India started looking at this issue completely differently. It began pushing for a more liberal, more modern interpretation, one that actually honored what Parliament was trying to do in the first place, end marriages that were, in fact, over.
The huge breakthrough came in a case called Dharmendra versus Usha. Here, the Supreme Court made a brilliant and crucial distinction. It said, hold on a second. For something to be a wrong under that old rule, it has to be serious misconduct, not just a mere disinclination to get back together. In other words, simply not wanting to continue a failed marriage, that's not the kind of wrong the law was meant to punish. This was a total game changer.
So, where did this all finally land? Where did this legal tug-of-war settle? Well, the law has now found a much smarter, more nuanced balance. It recognizes that marriages break down, but it still keeps a check on really bad behavior.
This table lays it out perfectly. In a case like Dharmendra, where you just have one person who doesn't want to reunite, the court says that's not a serious wrong. Divorce granted. But then you compare that to a case like Hirachand versus Sunanda. There, the husband was living in adultery, and he wasn't paying maintenance for his family. Now that, the court said, was serious misconduct, a real wrong, and they refused to grant him the divorce. See the balance?
And this new way of thinking isn't just stuck in one area of law, either. This idea that a marriage can just irretrievably break down is now officially recognized in other laws, like the Parsi Marriage and Divorce Act and the Special Marriage Act. And we're even seeing judges apply similar ideas in Muslim law. It's a real shift towards legal realism across the board.
So let's just quickly recap the journey we've been on. We've seen Indian law move from this really rigid it's your fault system to one that actually recognizes the reality of a marriage breakdown. We've seen that courts now have to do this delicate balancing act between the facts of a failed marriage and just being fair. And the big takeaway here is that not wanting to get back together isn't automatically a wrong, because the ultimate goal now is to stop preserving those painful empty shell marriages.
Which leaves us with one final big question to think about. The law is constantly trying to balance a person's freedom to move on with the need to be fair to everyone involved. Looking at this whole story, you have to ask yourself, has it found the right balance?